Okay, we're now recording. I'm coming from I can't remember which theater it is. It's the Hamilton soundtrack, the Hamilton stage. You got to be in the Zoom where it happens. Listen to Hamilton soundtrack. It's quite fun. But we're going to be looking at the one of the larger topics we're going to be doing, and this is your essay topic, which will have been posted before this video is up. But we're going to be looking at how EU competition law works, its development, its overall process, and areas including cartels, selling arrangement, and what are undertakings, questions of the ability to substitute products, and abuse of a dominant market position. And we're going to be looking at this over the next 3 or 4 classes because it is quite a long area. It is one I'm quite interested in that are kind of touching on my own research background a bit. And it is also your essay question, so I want to cover this a little bit more. We do have this week and then 2 more weeks of class. They'll be putting up video lectures. Competition law will bring us towards the end, and we'll probably wrap up with looking at EU state aid law, how certain arrangements by a member state will contravene state aid law, where the state is giving a benefit or effectively aid of some sort in the form of subsidies or tax reliefs to certain commercial enterprises, and how that is prohibited under EU law. So with competition law, we're going to be looking at this, and for the one time I need to actually see the left hand side of the screen. You can see there are two definitions of what it is and what competition law policy is. It's a policy to keep the marketplace in a manner that is not restricted as to reduce economic welfare, and government measures that directly affect the behavior of enterprise and the structure of industry. So there's 2 quotes just to really refresh them. We're going to be looking at as an overall topic where it is in the treaties, where it is in Articles 1, Article 101 and 102, TFEU, as well as some other related articles within the various treaties. And here, I'll pop up if I need it. Really, you can see there, it's the laws and policies aimed at controlling or regulating the exercise of market powers. When we're looking at competition law, we're making sure that the competition is fair, that everyone has a chance to engage in the market. It is not just one company or one economic activity setting the market, abusing their position of being the only one you can use, and making sure that the consumer isn't being unfairly affected or being ripped off effectively. And competition law is interesting because in the US it's called antitrust law, but when you think of it, it's how larger multinational companies can throw their economic weight around, and at what point does that, them just being a bigger company, become an abuse of position, and at what point are they stopping competition from actually occurring? So one of the examples, and one of the ones that's constantly being challenged or should be constantly challenged, depending on which way you want to argue it, is the position of Google. When you think you need to have a search engine, you automatically go to Google, but Google are using their position then as the go-to search engine to stagger results. While they may have the algorithm, well, they do actually have the algorithm, but Al Gore's ability to dance isn't the key thing there. But it's that Google have been accused, and possibly a little bit maybe incorrectly, of putting their product or their services as higher ranking results in the search algorithm. That when you're looking for a email service in Google, you'll get Gmail. If you're looking for a online storage, you'll get Google Drive. And while it makes sense that a company would be putting their own product forward, the position and the fact that Google is so dominant in the area of search engines, it does raise a bit of a question. Are they using that position? One I would look at is Apple. Are they using their position as effectively creating a monopoly over how you can use your Apple products? I know in the US they're trying to restrict your ability to prepare your own products. That you have to use and you have to not only engage with Apple authorized resellers and repairers for a higher cost, and because of how prominent Apple is, how closed off they are with their product, that can be in abuse of a dominant market position. But they haven't been as challenged because, like Google, they are based in California and they have a very strong influence on Californian law. Less so in the EU, but they still haven't been challenged enough, in my opinion. So you can see there the competition law, it's the importance of it from the UK white paper. It's there to, it's a life, competition is the lifeblood of a strong and effective market. It helps consumers get a better deal, encourages innovation by reducing waste and slack, and incentivizes companies to efficient organization of production. So competition is good. It pushes you to be better. Rocky was a better boxer because he had Apollo Creed as his competition. And that mentality put into business, it strives, it innovates, whether and what degree this is true or not is up to economists. We're lawyers, we don't need to worry about that unless you want to be a lawyer economist, and then God help you if you do. Just you're going to be dealing with a lot of numbers. It's very fun, very interesting areas of research. It's just I got into law to get away from numbers. But when we're looking at competition law, we have it there, and it's under the treaties. There are Articles 101, 102, 103 to 5, and 106 to 7 in sequence. How they are included in the treaties and how they prohibit certain elements. You can see there that monopolies, I've used the phrase dominant position, these can be interchangeable, which we'll be looking at in a little bit. We're looking at enforcement as well, and how how state aid can be allowed in relation to the state putting forward or state subsidizing, failing or not failing, but subsidizing companies that may not be the most competitive, but there could be a cultural or internal importance placed on that industry rather than just a pure economic or pure monetary association. We'll be looking at that in relation to state aid a little bit later on, of why certain and small domestic industries may be supported or given incentives by the state to continue, while in the pure capitalistic market, they would fail. So when we're looking at Article 1 and 2, which we'll be looking at in the next couple of lectures, we're looking at it, and they are directly effective, and they create rights and obligations for the individuals. And this has been seen in many cases, but just one there, the case 127/73. That's just showing that it has direct effect. We have the other relevant policies in relation to Article 3 TEU, Article 3 TFEU, Article 14, and 119. TFEU, looking at how the relevant parts and the broadness of anti-competitive measures are brought in, and how they're trying to facilitate and protect the internal market, which is what we were looking at when we were in class on the free movement of goods and services, people, capital, and how this is all aimed at protecting and encouraging and continuing that. Sorry, kind of episode off screen. How that all facilitates the existence and development of the internal market and the importance the EU has associated and continues to associate with the internal market going forward. And just Article 3 TEU, you can see there, the Union shall establish an internal market. It shall work for the sustainable development of Europe based on economic growth and price stability, a highly competitive market economy aiming at full employment and social progress, a high level of protection and improvement of the quality of the environment. It shall promote scientific and technological advance. So you can see there's a highly competitive social market. And the EU doesn't want a company to be able to rest as we have made us, we are now the Google of whatever industry. And the fact you can use that as a phrase or an idiom, we are the Google of X, Y, or Z, shows the position of Google as the larger player in their respective fields. And that's the question of, are they a dominant figure? And we'll be looking at, without getting too far ahead, how you can exist as the larger figure or the effectively as the industry in some cases, without abusing your position as the dominant figure. If you get there through capitalistic or economic prowess, that you just do what you do so well, you are the go-to company or go-to product, and everything else seems as a substitute or an alternative to your product if it's not available. Then we'll be looking at how you can exist and how you can operate without running afoul of Article 102. So that's just a case there, case 26/76, looking at the requirement for competition. And the competition shall not be distorted. It's the achievement of the objectives and the creation of a single market, achieving conditions of that there is no distortion, there's no artificial distortion. There's one large company who's abusing the situation and taking advantage of that they are existed in one member state where they could become a dominant figure, where they had the economic scale, effectively that they could produce so much and at a scale it was so cost efficient for them, they can just move into another member state, and the smaller companies that are operating there may not be able to compete with them. And it's to ensure that doesn't happen. And looking at the competition rules, and we will be looking at the regulation there, Regulation 1, 2003, and it's just the defining principle of simultaneous application of national law and competition law. So national law and how it works, pretty much if there is national law providing competitive benefits, they aren't running afoul of anti-competition principles and how that goes forward. Again, this is a bit more on the state aid side, but it is just an issue going forward. And then you can see economic efficiency and consumer welfare and the position of the consumer as another element of consumer harm or the detriment to the consumer. So it's the social side of why consumer anti-competition law, competition law policy, and law and policy is brought in, that's protecting the consumer. That you're not being ripped off, that the 650 million EU citizens are being protected from economic fraud. They're not being exposed to unfair economic burdens because one company could take advantage of the situation. And you can see there that it is the social side, it is the consumers, it is a structure of the market and competition. It does exist, that it is going forward. It's a multifaceted approach. And you can see there the industrial policy, innovation, public policy, society, social goals. These are all stuff that are part of what the EU, what the Parliament study and competition policy looks at. It's never just going to be one thing, because while we frame it as the internal market is the core, there are still the related elements, the social innovation in industry policy that have an effect and will affect in turn how competition law should work and how new industries, new developments can go in to effect. So this is what we're going to be looking at for the next process. I'm breaking up a little bit more, a more rigid division with this lecture, just because it's an essay question for you. And you had the other essay question from me in class that I felt more comfortable when there was more. I know students were actually watching, and I do appreciate Aaron and OJ for tuning in. But I just want to make sure everyone who's just relying on these notes has that clear division, so I won't be able to turn around and say this material wasn't explained, or I couldn't find that material in the notes. So it's broken down a bit more. You can see cartels. We'll be looking at the jurisdiction, the scope of them, the substance, and again, exemptions are always going to be a thing in law. At this point, I'm going to encourage you to watch Scarface. It has nothing to do with EU law. It's a good movie, and it deals with cartels. And the weekend's coming up, so why not? We're going to be looking at dominant undertakings. So again, the dominant position of a company, often classified as monopolies if they are the only one, or oligopolies if there's a few industries engaging in it. We're going to be looking at the general issues, the market, how market dominance works, scared me, abuse of this position, and justification of abuse, or where it can be allowed if they're so good at their business, they are in the dominant position and it's not without breaking the rules or the policy, really. We're going to then be looking at the enforcement aspects of anti-competition law, where if you are found to be in violation of competition policy, the fines, the mechanism of how this works, how the investigation works, and when it has. Then we'll be looking at the idea of undertakings and associations of undertakings. So it goes back to the dominance undertakings, but we're going to be looking at a little bit more specifically in relation to where companies have agreements. Not quite a cartel, but there are agreements for companies to engage in partnerships, and where if a company is a subsidiary, so if a company owns another company, so the way Disney and Marvel and Lucasfilms and the whole Star Wars thing, how they can engage with each other, how they can have an exclusivity agreement, and not run afoul of abuse of the dominant market positions, as well as the substitution of goods. If you can't get good A, and good A is the dominant market position. What are the alternatives? Are they that swappable, or is it a preference of choice and of taste and choice rather than availability? So there'll be a few things, and they'll bring us up to probably the end of next week, and then we're going into state aid. And I really just want to say, state aid isn't the aid given by the EU to the member states. I want to stress this now. It's the same thing with stressing the rules for the establishment of legal individuals in relation to free movement. It's just something students do wrap their head around as a concept of aid as help. It's not the monetary aid given by the EU to the member states. That's just, if you get that in your head, that's all you need to worry about for now. So we're going to be looking at cartels first, and you can see there that Article 101, Part 1, pretty much prohibits cartels. And this is a collusion between undertakings. So this is companies coming together to make these agreements. And pretty much, if you think of airline companies, how many airline companies are there in Europe? The 3 to 7 per member state, like non-regional airlines. Probably 3 to 7 per member state, 3 to 7. Off camera, I'm doing maths because 7. Let's say an average of 4. Let's say an average of 5. So 5, 3, 10. So to be 135 airlines. No, that's way too high. If you look at the amount of airlines in the member states, there aren't many. But if these airline agreements decided to put in price fixing, if they decided to have contracts say we won't compete with each other, and they set all the airline CEOs sat around the big table, big board meeting, as evil and Machiavellian as you want to think about it. If they met and they were discussing how shall we rate the game, apply any industry, oil, video games, soft drinks, I'm looking at stuff on my desk, booksellers, Amazon, there are plenty of other issues in relation to anti-competition and state aid we'll be looking at. But you can see that the key things there, they have the object or the effect, the prevention, restriction, or distortion of competition within the internal market. And in particular, they included examples there. And they are just examples. They aren't a full list because competition law can change. How the agreements, the undertakings can change can also be quite significant. Excuse me. But Article 101.2, any agreement or decision which decision prohibited pursuant to the article above shall be void. So it's just saying any of these articles are void. They're not allowed. But you can see there, there has to be some justification or some allowances, exemptions for these agreements, because sometimes they may have to bring in safety standards or there's some exemptions can be let. We'll be looking at that a little bit later on. But really, it's to stop cartels from forming, because excuse me, sorry, just pollen's getting me. It is a question of cartels, and when we're looking at this, we're looking at the definition of undertakings and what is the undertaking in question. What is the cartel activity? In Scarface case, it was quite clear. First, you get money, then you get power, then you get interest. But their cartel was drugs. Drugs are legal but cocaine in particular is illegal in the EU. So we have to look at more legal undertakings. And there is a very wide definition of what undertaking is, because it can relate to any good or service. And it can relate to capital management, it can relate to the sale of soft drinks, it can relate to something as niche as comic books being distributed by a single distributor now outside the EU, which I'm having a bit of an issue with because Diamond stopped comics being made and it may have destroyed the US money industry. But you can see there that it's a wide undertaking. And You can see that in the case of Hoffner versus Elser. The concept of an undertaking encompasses every entity engaged in an economic activity, regardless of the legal status of the entity and the way it's financed. So when they say the legal status of the entity, it could be the individual as a person, it could be a private limited company, a public limited company, partnership, however different member states define companies, regardless of the way it's financed. So whether it's cash, stock, whatever, it is quite a wide definition. And every entity engaged in economic activity. Economic activity is such a wide term. You can see there some further examples of natural persons, so people, professionals. We'll be looking at that in relation to how agreements between partners in firms, law firms, accountancy firms, doctors, dentist firms, financial regulation, that kind of thing. Public state bodies engaging in economic activity, so the Commission versus Italy. And it is a very wide definition from this. It really is any economic activity, any legal economic activity you can think of, it could fall in relation to an undertaking. Any activity consisting in offering goods or service on a given market. That is the definition from the Padlock case. So any offering of good or service, it doesn't have to be bought. It doesn't have to actually be consumed. It's just the offering of it to the public in a given market. So the given market could be a single member state, it could be a few member states in geographical proximity, or it could be the entirety of the EU and all 27 member states. And when you are talking about your essays, there are 27 member states. We went from 28 to 27, not 27 to 26, unless something really bad happened in the last hour because I turned off my news. Just keep that in mind. But it doesn't count where public functions are exercised. So the public function of the state, it's a public benefit, the public welfare side of the state, and that's in the Pochet and Pistre case, organization managing social security systems based on the principle of national solidarity and entirely non-profit making aren't economically active. So the social welfare side of the state, while engaging in an economic aspect, while they're engaging with the economy of providing social welfare, social assistance, social contributions, however it's defined, they are not economically active. That is the state running the state's internal aspects. And when we're looking at this, we'll be coming back to this, looking at this a little later on, but it's not a single economic unit. There has to be effectively two companies involved, two or more companies or individuals involved for a cartel to give rise. You can't have a single economic unit. So one of the examples of the example of Disney being the owners of Marvel and LucasArts, are they a single economic unit? While are they treated as separate companies but just owned by Disney? If you think about it, what companies soon aren't owned by Disney's? A scary thing to look at in this regard is look up the larger brands of the world, the larger companies of the world, the brand for food and entertainment. Look up who owns who. As a very small list when you get to the top. A lot of the companies, all the brands you would associate, they're all owned by a single company. Master Foods, who owns lots, Kellogg's, I think there's another one. Look up who owns who just as an exercise, and you can see, and then just how problematic this could go. Because at what point are they a single economic entity? Or sorry, economic unit? Are they a direct company supplying to, are they a paper company supplying the paper to an office that owns them? Or are they a paper company that is owned by an office and supplies to other offices and other businesses? And where does it look? And they were looking at this in the Centran case. That Article 101 is not concerned with agreements or concerned parties, consecrated practices between undertakings belonging to the same concern and having the status of the parent company and subsidiary if the undertakings form an economic union which the subsidiary has no real freedom to determine the course of its action on the market. So if the subsidiary exists solely for the function of providing the product they make up the supply chain, up the chain of ownership, then they will be a single economic unit. But if we use the Disney Marvel example, they are quite different. There can be a bit of, from what we gather, there is a bit of freedom between how Disney operates and how Marvel operates. And the Disney sub-companies they own, Pixar, LucasArts, news networks they own, they do have some degree of freedom that they aren't, can determine as course of action in the market. So they aren't a single economic unit. While they're a single economic entity of the Disney Corporation, the House of Mouse, we don't mess with the House of Mouse, the companies, the subsidiary companies could have significant freedom or levels of freedom to engage in their own market. And you can see there in the Akeza Noble case, which we will be coming back to look at in a little bit more detail, and it's peppered in throughout these notes. Control of the subsidiaries of smaller companies, companies owned by the other companies, is decided on a case-by-case basis. They look at the economic and legal links between these companies. Is the company fully owned? Does their entire economic development rely on their parent company? These are the kind of factors they do look at. And if they're found to be 100% owned by the parent company and supply 100% of their economic output and their economic engagement to the parent company, they will likely be a single economic unit. Why they're divided, who knows? There could be tax reasons probably, or why. And when we're looking at this, we're looking in the Breyer case that we're going to be looking at agreements of the inclusion. Sorry, we're going to be looking. Article 101 includes agreements, decisions, and concerted practices. And the first one we're looking at here is agreements. I have that as a separate slide. But agreements have been given a significantly wide scope. So if you remember from contract law, what a contract could be is quite a broad term. It can be an agreement between you buying a coffee or you buying a coffee supply chain. It's either buying a cup in your local coffee shop, not Starbucks, support the local industries because they make nicer coffee, or buying the entirety of a coffee supply chain in Ireland. These are both contracts and they will both follow the same principles. But the concurrence of wills and between the economic operators, it can be quite significant. And that's what we're looking at with these agreements. It doesn't have. It may not always be a strict contract. It can just be an agreement where they don't write it down for legal reasons, or they agree in principle or a handshake agreement that a certain practice will be the correct way. Effectively, it is the concurrence of wills that they are going in. They agree to go in that direction, and it can be. Sorry, I thought I had something else. It can be that agreement to go in a certain way. Concerted practices will be where this happens as a result of the decisions without it actually being an agreement. It's a weird distinction we'll be coming back to. But it's that kind of, look, no agreement was taken, no understanding was made, but we are all moving that way because it's an unwritten, it's an unsaid, unspoken deal. And decisions then are institutionalized agreements. This is to ensure that the rules and agreement between undertakings are not circumvented by an association. And we'll be looking at this in relation to the Wooters case a little bit later on, just how associations work and how decisions between them can work. And with the agreements in particular, they can be vertical or horizontal. They can be between companies of equal status, they can be between competitors, or they can be between companies in different areas of the supply chain. And they're all captured under Article 101. And Article 101 in the contestant and agreement case, it does not lay down any distinction between those agreements based on whether they're made between competitors operating at the same level in the economic process or between non-competing persons operating at different levels. For this purpose, it is irrelevant whether the parties to the agreement are not on not on a footing of equality as regards to position and function in the economy. So this can be an agreement between the largest supplier, largest producer, largest company in an industry and a small company on their supply chain. It could be agreements between Apple and Microsoft. It can be agreements between Pepsi and Coke, Adidas, Nike, and I can't think of a third sports clothes. But it can be these kind of agreements, and it can be between any company, any other company on their supply chain. And as we look at this, it has to be there has to be the concurrence of two wills. You can't unilaterally impose will a decision on a smaller company. They have to agree to it, whether it's reluctance agreement or they're agreeing to it because they have no other choice. But they can't be forced into that situation. And when they're looking at this, it is a question of unilateral imposition or concurrence. Do they agree to it? Or are they agreeing to it because if they don't, they're going to run a business, or they have to agree to it because there's a gun, literal, not literal, but a figurative gun to their head. And in this case, there's a fine line of where do you draw the. It's really a question of economic duress. So, at what point do you have such a strong bargaining position they have to accept it, or are you forcing them to accept it? And it can be quite tricky from a legal perspective. Where do you draw the line? From an economic perspective and business point of view, it might be easier to look back, and particularly in hindsight, you know, they made that decision, they made the correct one, they didn't have to, but the alternative was massive profit losses and reduction in whatever the company. But that still would have existed. And they're looking at this in Ford versus Commission. And in this case, Ford informed German dealerships that they could no longer order right-hand drives due to the price increase on the British market, and that right-hand drive cars could only be ordered by British dealers. This was to prevent German dealers exporting the car to Germany and harming the British dealership market. And they were looking at this that was this a unilateral imposition, or was this an concurrence? Was this an agreement? And the court, you can see there, they held that such a decision on the part of the manufacturer does not constitute on the part of an undertaking a unilateral act. On the contrary, it forms part of a contractual relationship between the undertaking and its dealers. So it was letting them know we are not making right-hand drives available in this car in Germany. They'll still be made available, but only to be bought in the UK. And that was allowed. That was just how the relationship went. They're still selling cars to Germans. Ford was still selling their cars to Germany and the German dealerships, but they couldn't buy the cars with the intention of exporting it to the British market because they were undercutting the British dealers and harming the British industry, and that was harming Ford's British market share. And you're kind of wondering, but they're selling a car, but they're not selling the cars they want to buy. Is that not, and they're being told they're not getting them? Is that not a question of unilaterally imposing their Ford's will on the German dealership? And they kind of clarified and limited this in the Bayer versus Commission case, in which a German pharmaceutical corporation sold medical devices through distributors in other member states. And the prices were indirectly fixed by the National Health Services, so prices were higher by 40% in the UK compared to France or Spain. And because of this, 40% price difference, some companies decided we can sell and make a profit. And the distributors in France and Spain started selling their product at the 40% lower rate they bought it from in the UK. To protect the UK distributors, Bayer only provided stock to France and Germany that would satisfy their national markets. So they would only give them enough to satisfy what they had researched to be what they would need, because any surplus was being sold or would be at risk of being sold to the British markets and affecting the British distributors. And the court said this was not an agreement, as it required the existence of an acquiescence by the other partners, express or implied, in the attitude adopted by the manufacturer. In other words, there must be acceptance through actual compliance with the unilateral measure to create an agreement. And you can see there that on appeal, the courts were looking at it. that the aim is nuts. But you can see there, sorry, on appeal, the American commitment existence of an agreement which itself is neutral and a measure restricting competition itself does not amount to an agreement. So really that's what the courts were saying, and it's a long-winded way of saying it. But this question then goes to constructive markets. And when courts were looking at this, they were looking at it as the idea of concerted practices to bring within the prohibition of Article 101 a form of coordination between undertakings without having reached a stage where there's an agreement properly so called has been included, knowingly substitute practical cooperation between them for the risk of competition. So they haven't come to the agreement, but they've come to the agreement, if you understand the subtle differences. That one might not work as well with audio because I'm kind of air quoting, but that was in the Imperial Chemical. An agreement had been reached without an agreement being made. They understood a practice, they understood the position, that if you examine the behavior between companies, there is cooperation without it having been declared of this is what we are going to do. It's just, this is a bit more retroactive where you can look at the practice as well. There's something going on there. A company wouldn't have left X amount on the table, or they wouldn't have left that marketing space available unless there was a requirement to do so. And when looking at this, this is what I've talked about in relation to oligarchies, where there's a few large, powerful companies working in an industry. And a price increase for one would very well result in a price increase for others who know the practice and methods of the first company well. And again, in Imperial Chemicals, they looked at this and said that parallel behavior may not itself be identified with a concerted practice, but it may, however, amount to strong evidence of such practice if it itself leads to conditions of competition which do not normally correspond to normal market conditions. So if one company puts up their prices, will it not make more sense for every other company in the market to keep their prices at the lower level and therefore say, look, we have a cheaper and better product? But if they all put it up and say, oh, no, it's the done thing, it's the industry norm, it's the industry honor system, that's kind of a concerted practice. And they were looking at this, that companies must not cooperate with their competitors in any way whatsoever in order to determine a coordinated course of action in relation to a price increase. So companies can't sit around and go, well, if we put up our price, we can make a bit more money, but it would require everyone else to agree to put up their price. You know, I'm not asking you as other companies to follow suit, but you know, if we do it, follow suit. Wink, wink, nudge, under table bribe. That type of situation. So they do look at that and the cooperation between competitors. There can be stages where cooperation is just, it's an industry, there can be a history of cooperation, it makes sense. One example of cooperation that wouldn't be concerted practice is a couple of years ago, two very senior executives from the Coca-Cola company had acquired the full Coke formula, and they went to the Pepsi Corporation, PepsiCo I think it's called now, and they said, look, we have the Coke formula, we'll sell it to you for millions. And Pepsi would have effectively been able to buy and make Coke. And Pepsi called the FBI and arranged a sting operation. And that was cooperation, that was an engagement between their competitors. But it wasn't a concerted practice. They were just doing a good deed, effectively. So where you find the line between a good deed and cooperation depends on the context. And you look at it from the economic aspects of it. Of why would other companies make this decision? At the moment, we're seeing a lot more cooperation with companies, and we're seeing a lot more willingness because of there's a crisis going on, and they might be looking at more humanitarian aspects and like companies pitching in and saying, look, there's a crisis, we will help competitors. But if you're doing that and it was having a negative effect on consumers, they will be looking at it from a concerted practice perspective. And it is just a question of the overall context of where this is coming from. And when we're looking at parallel behavior, we look at it, that parallel behavior itself can't be caught under Article 101. But just because the company, just on itself, that the company follows the other companies in an action, but that itself isn't always going to be enough. It has to be, you have to look at the other factors of the market. If they raise their price, what was the cause of them raising their price? Are they now advertising themselves as a premium product, or are they just raising their prices because they have to? Are they doing it early because they know the industry will have to raise their prices in the next 3 to 6 months? If they do it now, they have an extra bit of time to get profit. And really, it's a question of, is there contact between the companies and their undertaking? Is there actual messaging go back and forth saying, look, we're raising our price in the next while, it's a heads up? That would be a breach of Article 101. But if companies are just following an economic trend and it makes sense for the price to rise once one company raises their prices, the rest to raise the price from an economic sense with no collusion, no cooperation, that can be allowed. And you can see there that the logic of the market, if it makes sense in the broader sphere of the economic deal they're working in, and for the Elstrom case, that won't be running afoul of Article 101. But these have to be carefully examined. It can't just say, oh, we're following the leader in the industry. That itself may not always be a correct logic. And again, they need the interstate development. This, because we're dealing with EU law, there has to be an interstate engagement. If it's internally, the national laws will apply, because national laws, we saw, has to incorporate anti-competitive approaches. It only applies with an Article 101 TFU will only apply with an interstate dimension. And that was in the Constant and Girding case. That the concept of agreement, which may affect the trade between member states, is intended to define in the laws governing cartels the boundary between the areas respectively covered by European law and national law. It is only to the extent to which the agreements may affect trade between the member states that the deterioration and competition caused by the agreement falls under the prohibition of European law. So again, as we saw with the free movements of everything, there has to be the interstate, there has to be the cross-border element for this to actually take effect. And when we're looking at this, though, bear in mind how broad the definition and the scope of the interstate element is. If the agreement is capable of constituting a threat, either directly or indirect, actual or potential, to the freedom of trade between the member states in a manner which might harm the attainment of the objectives of the single market, that would be enough to give rise to the interstate dimension, the cross-border element. It doesn't actually have to happen, but just that it's likely, or there's a strong potential for it to actually happen. And because of this, we're going to be, the courts are looking at this, and the commission who investigates, we'll be looking at this a little more in the enforcement aspect. The commission who investigate the breaches of Article 101, they can't, and they aren't interested in pursuing all agreements that might fall within the definitions of Article 101, because there could be so many. And they have the rules for thresholds, which we'll be looking at in the enforcement, of is it worth the time and resources to pursue this? Is it something that the commission actually can pursue? You would have looked at this in relation to preliminary ruling and the question of supremacy for EU law. If there's a derogation, can the commission go after every single instance? You would have looked at this last year. Can the commission go after every single case? They can't. They won't have the resources. They won't have the time. The courts will get inundated, and there will be backlogged so much they won't get anything else done. So we're going to stop there before we move on to cartels and the actual substance of how they actually work. I'm going to stop the share. And I'm going to stop the recording.